Welcome to Road to Recovery.
Hi, everybody. Welcome back. This is Sagi Shaked with the Road to Recovery podcast. And today we're going to do part 2 with Michael Greenspan from New York. So, Mike, thank you for being on part 2 of the show. And we promised everybody we're going to talk about a trucking case in New York. So I want to ask you, have you ever had a situation where in New York you're dealing with, because I know you do a lot of truck accidents, you're dealing with the snow, because that's something we don't really see in Florida, snow. And I believe I've been to New York a bunch of times when it snows. So in your years of practice, have you had that situation? And if you have, just tell us a little bit about the case, and then we'll ask more questions about it.
Sure. So yeah, I mean, snow and ice are a fact of life in New York, and especially around this time of year. So what often happens in motor vehicle crashes is that the vehicle which is at fault is a government snowplow or a truck of some sort. And you would think, well, wow, this is great. If they're at fault, you can go after them and there won't be any problems with coverage. But this being New York, it's never easy. So first you have to figure out who is the right entity to sue, and you've got to deal with the right time period to go after that specific entity. So an example we had is we had a man who was going down a pretty steep hill, and there was a snowplow in front of him. So they come to a light, they make a left turn onto a state roadway, and the plow is in the right lane and decides to pull a U-turn from the right lane right in front of my client, causing a bad crash and the client seriously hurt. Now, this presents a number of problems because since we're dealing with a village snowplow, we've got to go and sue this village. But the thing with snowplows is that if they are actively plowing and salting and sanding, and I know, Sagi, you've seen so many of salter and sanders in Florida during the many snowstorms
Every day.
in Florida. If the plow is doing that, they get the benefit of a statute which imposes a reckless standard on them. So the standard proof that we as personal injury attorneys have to surround is not just simple negligence. You have to show that that snowplow operator was reckless. And that is very, very challenging to do.
What happens if you can't show that it's reckless? You just have no case?
Your case is going to be dismissed on summary judgment long before you ever get to a jury.
And do the federal motor carrier safety regulations apply? Because we know if the vehicle has a combined weight of over 10,000 pounds, then some of those federal regulations do apply. How does that work with these snowplow machines in New York, at least?
Well, it's still those federal regulations are important because a lot of times these snowplows will not necessarily hit that weight, but even if they do, it's still the fact of what are they doing? What is the activity that they're engaging in to give them that reckless standard? And and the courts are very protective of those municipalities in New York. So conduct that we would think as regular people is reckless to a Supreme Court justice, and that's the trial level judge who will be deciding these cases. It's going to be something totally different.
So that's like what, an abuse of discretion? Is there any set case law that talks about what constitutes reckless and what doesn't?
Yeah, there's a lot of case law on it. And that's one thing, it's a big difference between New York and Florida. In New York, we allow interlocutory appeals. And because of our population, the amount of case law on almost any aspect of a case from its inception to post-trial is huge. So there is a case on just about anything, any issue of discovery, any issue of practice. And of course, what constitutes reckless activity. So you have some extreme cases of, let's say, a police officer going the wrong way down a one-way street because somebody, was speeding. That's an example. And you've had other cases where a police officer has gone through a intersection with a red light with his sirens and his horns going, and that's found not to be reckless.
Yeah. So when you talked earlier, you talked about summary judgment, and in the first episode, and you talked about it again here. I want to talk about summary judgment in these trucking cases because you talked about it, one in the threshold area, but also in the liability. But I would really want to focus on liability here. because there's something that's different in New York than there is in Florida when it comes to summary judgment. And I learned this again from talking to you. I'll tell you what Florida does. So let's say there's a rear end collision involving a truck or a car. You move for summary judgment against the at fault party. That's great. They'll usually admit it before you go to the hearing. And that's all you get. That's the benefit of it, that they admitting fault. Is that different in New York? And how is that different? And what are the benefits of obtaining summary judgment during the course of litigation, aside from someone just, you having a summary judgment saying they admitted it? Tell us about that.
Sure, it's much different, and if used properly, summary judgment is a real effective tool in the plaintiff's arsenal. So, if you get summary judgment, you now, from the date the judge issues that order granting your motion, interest starts running at the rate of 9%. So if you get interest running and it takes 2, 3 years, like some of the boroughs in the city, it's going to take a couple years till you finally get into a jury. Interest running at 9%, which is added on to what the jury's verdict is very helpful and can be very substantial. And in trucking cases, if you've got a catastrophically injured person, even just a very significantly injured person, those numbers add up.
You mean, let's say you get summary judgment, we'll say in 2025, and then you try your case in 2027. We'll just use a round number of $1 million. Are you going to get interest from 2025 as if you had a judgment of $1 million?
Yep, you get 2
Wow.
years of interest from the date of summary judgment being awarded to the date of that verdict. So if you've got $1 million, add on 2 years of interest at 9% or $180,000.
Wow, that's completely. I wish they had that in Florida. That'll help settle cases, but they don't. There's a strong insurance lobby here in Florida that would never allow that. In fact, they're always trying to chip away at our laws and take away people's rights. It's just something that they do. So that's it. Does that tool also apply if you're doing it on the permanency side, on the threshold side?
Yeah, well, because the whole point is you want to show summary judgment on the issue of liability. Now, in some parts of the state, and this is why an out-of-state attorney has to be very careful, in order to get summary judgment, you have to prove not only liability, but the serious injury threshold. So whereas downstate in the lower Hudson Valley or Westchester County, where, that's our domain, and, anywhere north of Yankee Stadium up to a point where that other district is, you don't have to prove serious injury threshold for summary judgment. But the point is you want that 9% running. But this is a key, and it's good that you brought that up. If you go to trial, even with summary judgment on the issue of liability decided in your favor, and the jury, answers those threshold questions against you, you get nothing. So it's really important. That's why when you want threshold decided at an early date. And the way the practice works in New York, sometimes you're going to move for summary judgment twice. Once on the issue of liability, get that straightened out. And then when the case is on the trial calendar after what's called note of issue, that's just simply the filing of the document that puts you on the trial calendar. Now you want to get the threshold determined, because if you do it too early, you're going to lose, because the defense will rightly say, wait a second, we haven't finished discovery. We have to have our experts involved. So it's premature. But the other thing which is important about successfully moving for summary judgment is it's just such a powerful tool when you walk into a jury room. Because look at it this way. You go to a jury room, and New Yorkers, look, juries are cynical. And there aren't judges in the room like there would be in Florida. So we're in a small room. It's just the two lawyers, or however many lawyers there are, speaking to these jurors. So when you walk in as the plaintiff's lawyer, and you can tell these folks, look, in a case like this, jury usually has a lot of work to do. You've got to hear the facts, testimonial exhibits, read all the information that you got, and then answer between one and as many as 5 questions about who is at fault, and if both were at fault, to divide it up, 90, 10, 50, 50, whatever it is. But here's the good news. You don't have to do any of that. A judge has already decided 2 things. Number one, that the defendant was at fault. And one of the things that we do is we want to get that defense of culpable conduct thrown out, because New York's a comparative fault state. So whatever your verdict is, if a jury says the plaintiff was at fault, whatever percentage the jury assigns to the plaintiff, you now deduct that from the verdict. So what we like to do, and we have a really good track record of, is we want that comparative fault defense thrown out. So we can say, and members of the jury, the judge has already determined that they, now you turn to the defense, are 100% responsible.
Yeah, that's always nice.
It's
Now,
great.
you mentioned some stuff in jury selection that threw me off. Like in Florida, when we're picking a jury, I was just picking a jury 2 weeks ago in Tampa, but when we're picking a jury, you have the entire panel there. And then in that case, we had over 30 plus jurors all at one time. There's a court reporter typing down everything. Defense counsel is there. The judge is there. And that basically, you get an hour to 2 hours, depending how much you need. I mean, with 30 plus jurors, it's hard to do. But are you telling me New York is different? There's no court reporter, no judge when you're picking a jury? Is that what you
That's
guys are?
correct.
Wow,
And
that's
yeah,
absurd.
it,
Totally different than the way we do it here. Completely different. So how do you, like, if you have, for example, a disagreement as to what the juror said, do you bring the juror back in front of the judge? Is that what you would do?
well, it depends because the rules are different in the five boroughs than north of Yankee Stadium. So let's say you're in Westchester County, where we're based, and now you've got a disagreement with defense counsel. So the two of you are now going to speak to the judge. You go out of the room; it's just the two of you, and speak to the judge and explain what occurred. Now, sometimes you'll also have to bring in the juror because let's say a juror is clearly trying to get excused. And they can, like in a premises case, we had the famous guy who was the landlord with a backache. So he had no use for injured people. And yes, he also had no use for defendants. So this was someone the judge had a question and sir, let's really talk about this. But sometimes you have defense attorneys who obviously want to get rid of and discriminate against non-native English speakers. So you may have a Batson challenge you have to deal with, and to show that, hey, look, I have an Hispanic plaintiff, and isn't it interesting? They're trying to kick off every single Hispanic juror. So you've got to now fight that out and discuss that and argue that in front of a judge. But all that's out of the view of the other jurors.
That's a good point. We have those same issues as well. It's just when we do our cause challenges, we don't do them in front of the jury. A little different, I guess. Let me ask you. You mentioned the five boroughs here, and I guess each one is a little different. There's ones that are more liberal, ones that are more conservative. First of all, how long does it take to get to a trial? Because I know some of them are just take forever. I hear in New York, in Florida, depending on the judge, but you're talking about 18 to 24 months, you can get yourself a trial. How tell us about New York and the different boroughs. How long does it take to get to trial when you're there?
Oh, in boroughs like the Bronx or in Brooklyn, it can take a couple years. And when we say a couple years, that's from when the case is put on the trial calendar, not from when you file suit. Because when you file suit in New York, you don't, like in Florida, others get like, well, it's a track and how we expect it's going to be ready when and now have a trial date. Not at all. And while they will, for discovery purposes, decide whether it's on a standard or more complex track, you still have a lot of time before you can actually get in front of a jury. And again, in those particular venues, it could be a couple years. In Queens, and Queens has rules all unto its own that even other New York lawyers have trouble following. It's just that's the way it is, and you have to know your area. So if you're an out-of-state attorney, you see, wow, great, I can do this in New York City. Well, the rules are different in Queens than they are in Manhattan, and they're different in the Bronx and Brooklyn and something else because the Bronx and Manhattan are governed by the rules for our appellate division first department, which are different from the rules that will govern the Brooklyn and Queens. So you've got to know that. And case law is different in each of those divisions. So you have to give some thought as to what venue you're going to bring your case in and time periods. So there are a lot of factors, and just even the way motions are handled, even jury selection. It's really something that have a lot of thought has to be given as to where you're going to put that case in, because that also brings in a question about venue that is different. I know in New York and Florida. In New York, you can choose the venue of where the plaintiff lives, where the defendant lives,
Ooh.
or where the crash occurred.
Yeah, we don't have that. Ours is completely, I mean, it's somewhat similar. We can choose where the defendant lives or where the crash occurred. But we definitely cannot choose. We can't, they call that forum shopping here, where the plaintiff lives, because a lot of times that would be really an amazing thing to do. But I can imagine going back to the five boroughs, clients would get really frustrated. Do you tell them up front, hey, this could take 5 years before we see the day of light for this case if you have to try this case?
Oh, you absolutely have to. And frankly, one of the things we do is have that discussion with clients, is because it's going to go much quicker in Westchester County than it is in the Bronx. And you have to decide, do you really want to go all the way through the Bronx as opposed to going into Westchester? Now, Westchester is a much more conservative venue. Now, yes, they vote blue, and demographically it's very liberal, but I will tell you, you get those people into a jury room and they suddenly become a room full of insurance adjusters. They can be
Yeah.
very cynical, and it's, Westchester juries for many years have had that, have definitely had that label. Things have changed in recent years. You're now getting more of a jury panel which is emblematic of the community. So you're starting to get much better verdicts in Westchester, but still, it's a real question. And I think that it's something you have to discuss with the client. They have to know. And look, most clients will trust you. They'll say, "Okay, now I get it. What do you think?" But now you've had that conversation, because you would never want to have a conversation with a client. Why is it taking so long? You didn't tell me that.
Right. Right. Yeah.
You never
Yeah.
want to have the "you didn't tell me that" conversation with a client.
Clients are always, and I don't blame them. They don't want to hang around to these cases. We're used to it, so for us, it's normal, like you.
Hmm.
And they think, sometimes a year is too long, and I get it. Um, Before we leave, there was some interesting article that I read because you mentioned the Bronx and how favorable it is compared to Westchester. So we have the same thing. Miami-Dade County and the Bronx are always number one and two in the country for what the insurance company has labeled judicial hellholes. I don't agree with that comment. I think they're a great place to try. They call them that. The insurance company calls them judicial hellholes because I think they get hurt with the verdicts here because people are understanding and they can see that people's pain and everything that they go through. The verdicts are better in Miami-Dade County than most of the parts of the state. How do you find that for the Bronx as well? When you guys have that label, the negative insurance label, of course, and they want to spin everything their way.
They certainly do. And look, the places like the Bronx can be a very favorable venue for damage cases, and the real catastrophic ones, which justify big numbers. A Bronx jury can be very willing to do that, but also recognize that even in Westchester or other places, you can get large verdicts if the economics are there.
Mm,
These same bunch of insurance adjusters who can be on a jury, they recognize, so if somebody's a high wage earner and now they can never work and they believe, oh, wow, this person is horrible and will never work again, that even in Westchester, they get. And then once they see that, then they're much more willing to believe in pain and suffering. So there are some definitely some considerations to go through, and timing of it, size of verdicts. But because we have that law in New York that permits trial judges and our state appellate courts to reduce verdicts, the insurance companies can complain all they want, but that's why they can drag it through the system for a long time.
right. They have the money and they're holding our money and our clients' money. But so we're right now at the end of the show. Mike, you've given us a lot of your time, and we truly appreciate you sharing your knowledge and wisdom and educating us on the New York law and also some of the pitfalls of New York law if you don't practice there. So, Mike Greenspan's your guy in New York. If you have a New York case, keep Mike in mind. He is the guru out there, knows what he's doing, and very well educated and teaches all about New York law. So, Michael, thank you again. And how can, if someone wants to contact you, you want to give them your website just so they know how to reach you?
Sure. We're at www.greenspans-law.com. It's my last name with an S at the end of it, -law.com. And we've got a whole team. We're ready to help you out. And listen, I love working with out-of-state attorneys because we look at it as a team building endeavor, and let's work a case together.
Love it. Thanks for joining again, Mike, and thanks for again sharing your knowledge and information to better educate all of us out there. I appreciate your time again. Thanks,
My
everyone.
pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.